1 minute. Good evening, everyone. It is now 6:00 p.m. this Thursday, September 22nd, 2022, and with 4 members present of the JGO committee, we have established a quorum and I hereby can call this public JGO meeting to order. Moving on to item number 2 of the agenda, I would like to make some administrative announcements. First off, the female restrooms are located immediately to the left as you exit, the double doors to my left, and the male restrooms are located immediately to the right as you exit the double doors on my right. Sandwiches and water are provided for everyone present here this evening, so we welcome you to help yourselves to it. We have a sign-in sheet for everyone present here, and we would like to ask your cooperation to please sign in on the sign-in sheet, and please give us your contact numbers just in case we need further clarification from you. We appreciate that. And finally, the committee appreciates your cooperation, and we would like to ask all of you to please silence your electronic devices at this time. I want to make an announcement that the recording of this JGO meeting is the official journal of this meeting for legal purposes, but it does not relieve the legislative assistant assigned to the committee to produce a committee report. The agenda for today was issued on August 30th, 2022 in compliance with the Open Government Act. Copies are provided here, as well as copies of the initiatives that we will be addressing on the agenda today. And the last item on the agenda is the proposed rule for the judiciary, and they are provided here. Physical copies are located in the back of the room. I will now introduce you to the members of the committee. I am Selena Babata, and I serve as the chair of the JGO committee. To my immediate left, we have Representative Richard Lizama, who is the chair for the Public Utilities, Transportation, and Communications House Standing Committee. To my immediate right, we have Representative Edwin Probst, who is the chair for the Gaming Committee, House Standing Committee for Gaming. And to his right, we have Representative Donald Manglonia, Precinct 7, Rhoda, and he serves as the chairperson of the Ways and Means House Standing Committee. Also, we have present here today, our legal counsel, House Legal Counsel, Mr. Joseph Tyrone. We have Mr. Cameron Nicholas, the legislative assistant assigned to the JGO. And to keep order in today's meeting, we have our senior sergeant at arms, Mr. Pedro Tawai. We also have our IT manager, Mr. Jonathan Diaz, to assist the committee this evening. At this time, I would like to recognize Representative Donald Manglonia for the proper motion to adopt today's agenda.
I move for the adoption of today's agenda.
Motion has been made and has been seconded. Are there any questions or concerns on the motion? Ready? All those in favor, please say aye. All those opposed, please say nay. Today's agenda has been duly adopted. Before moving on to public comments or statements from the members, I wish to make an opening statement, so please allow me a few moments of your time. On behalf of Representative Edmund Villagomez, Speaker, House of Representatives, I would like to thank the staff of the multipurpose building for accommodating us this evening. Also, on behalf of our executive director, Mr. Perry Tenorio of the Legislative Bureau, want to thank the staff for accommodating us after hours. I want to express a warm welcome, bienvenido para todos Hamzu, who are present here this evening and exercising your civic duty to provide and attend valuable input on matters before this committee. It is important to take part in our democracy, and your presence here this evening is much appreciated. Tonight, we are here to receive comments on the items on the agenda, which are 4 legislative initiatives and a proposed rule from the Judiciary. Allow me a few moments to explain what the proposed rule and why it is critical to include it in our agenda this evening. Excuse me. The communication from Chief Justice Alexandro C. Castro was received by Speaker Edmund Villagomez on August 8th, 2022, and the CNMI Constitution vests the Chief Justice the authority to propose rules governing admissions to and governance of the Bar of the Commonwealth. Such proposed rules shall be submitted to the legislature and become effective 60 days thereafter unless disapproved by the legislature, by a majority of the members of the legislature. The proposed rule would allow attorneys with limited admission license to practice in the Commonwealth. The proposed rule would allow attorneys with a limited admission license to practice in the Commonwealth for a maximum of 8 years without having to take the NMI bar. Tonight, we will receive testimonials from the public and community at large, both oral and written, on the following items of the agenda. House Legislative Initiative 22-001 to amend Article 3, Section 14 of the Constitution of the Commonwealth of the Northern Mariana Islands to authorize the election of a Commissioner of the Department of Public Safety and for other purposes, introduced by Representative Edwin Prost. Also tonight on the agenda is Senate Legislative Initiative 22-02, Senate Draft 1, to propose a constitutional amendment to Article 4, Section 4 of the NMI Constitution to require the delegate of the United States House of Representatives from the Northern Mariana Islands to provide a report to the legislature in a joint session. Senate Legislative Initiative 22-03, Senate Draft 1, to amend Section 10 of Article 3 of the Constitution of the Northern Mariana Islands to restrict the governor's emergency powers to mobilize available resources to respond to that emergency within the executive branch, but not including the legislative branch, the judicial branch, and autonomous agencies, pre-filed by Senator Justo S. Kituga. Senate Legislative Initiative 22-04 to propose a constitutional amendment to Article 10, Section 2 of the NMI Constitution to require the governor to provide a report on the social, fiscal, and economic impact of tax exemptions, pre-filed by Senator Justo S. Kituga. Lastly, on our agenda, we have Judicial Branch Communication 22-7 from Chief Justice Alexandro C. Castro to the Speaker, submitting proposed rule of admission 73-2, Title 9 of the NMI Supreme Court Rules, submitted on August 8th, 2022. At this time, I would like to ask if there are any members of the committee who wish to make any statements. Excuse me, if there are none, we will move on to item 3. But before I do that, I want to advise everyone that we are live streaming on Facebook and YouTube and the Northern Marianas Legislature website. And just to let you know that when we do go on recess, it will still be live streaming. Moving on to item 3 of the agenda, I now open the floor for public comments. for those in our audience who wish to do so. I ask that you please come up to the podium, state your name and the entity you represent. And please, we ask that you keep your comments to 5 minutes and relative to today's order of business. Thank you. The floor is now open. You can make comments on any item of the agenda. Yes, we are on item 3, I'm sorry. Public comments. Yes.
I was going to say, may I please the court, but I think I'm in the wrong forum. But be that as it may, Madam Chair, members of your committee, I'm here actually to testify on the Supreme Court's communication to this committee with respect to the proposed change in the rule.
Excuse me for
Permission.
one moment. I want to check if your microphone is on.
It is on.
I think you need to speak directly to
Okay.
it. I'm sorry.
All right.
You may proceed.
All right, thank you. I've prepared a statement, and I drafted a letter, and I sent that to the chair of this committee. And I just like, for the record, to state what that letter states at this point. Representative Babauta and members of your committee. Yeah, all right. Thank you for the opportunity to comment on interim Supreme Court Rule 7-73-2. The rule amends the rules of admission to permit a one-time extension of the limited government attorney license to allow licensed attorneys to represent the Commonwealth Government or Micronesian Legal Services Corporation for up to 8 years without sitting for the NMI bar. The rule also requires all attorneys admitted to practice pursuant to Rule 73-2 to participate in Judiciary Community Outreach Program for at least 10 CLE credits per CLE reporting period. In my capacity as the Chief Legal Officer of the Commonwealth Government, responsible for providing legal advice to the Governor and all executive departments, representing the Commonwealth in all legal matters, and prosecuting violations of Commonwealth law, I fully support the interim rule. Recruitment and retention for government attorneys is a challenge for the Commonwealth, and it is exacerbated by the 4-year. Having served nearly 7.5 years now as Attorney General, I find that many government attorneys provide the bar examination requirements as the primary reason for not renewing the contracts of employment. These attorneys cannot practice in any other jurisdiction offering limited or reciprocal admission rather than sitting for another bar exam. Other attorneys leave because they have not invested in forming a strong and permanent community within the Commonwealth, largely because the bar examination requirement set an initial expectation that their time on island would be temporary. The turnover of attorneys with 4 years of experience practicing in the Commonwealth, after gaining familiarity with the customs and culture of the people and agencies, and expertise with Commonwealth laws, results in significant expense to the Commonwealth. The cost of hiring a new attorney to replace one who is currently employed by the CNMI governmental entity is no less than $14,000. This amount does not include the time and expense of training new attorneys in the Commonwealth, practice, and substantive law. In addition, there are few disadvantages to the Commonwealth in allowing a government attorney to continue practicing beyond 4 years. In order to be granted limited admission pursuant to Rule 73-2, The attorney applicant must be licensed to practice in an ABA-approved jurisdiction. Government attorneys granted limited admission cannot work in private practice without sitting for the Sinamay bar, so they do not present any competition to locally barred attorneys for non-governmental clients. In addition, even without sitting for the Sinamay bar, these attorneys have more knowledge of Commonwealth laws and provide more experience and knowledgeable service to the Commonwealth than a new off-island hire. To qualify for an extension, the applicant must continue to meet all requirements for limited admission, including maintaining good standing in every jurisdiction in which the attorney is admitted. So there's little risk that the extension will allow qualified attorneys to remain in practice. The new requirement for government attorneys to participate in Judiciary Committee outreach programs, in addition to the bar's continuing education requirements, will also serve the Sinamay bar at large. In the interest of enhancing the Sinamay's government ability to recruit and retain experienced government attorneys to serve the Commonwealth and reduce expenses associated with new hiring from off-island, I urge you to approve Supreme Court Rule 73-2. Thank you so much for this time.
Thank you, Attorney General Manabusan. Dr. Narciso Smoset. The floor is still open for other public comments.
Good evening, Chairwoman Babauta.
Good evening.
Good evening, and to the members of this committee. I want to second the motion on that approval of that proposed rule of admission 73-2. I myself, I believe that it is a very difficult task to recruit attorneys to the islands. And I think that once they come over here and they start working for the government, the observations that I've had over the years is that most of them anyway stay in the government. So it really doesn't affect much the private sector. But it'd be nice, of course, for them to try and take the bar, just for the show, perhaps, maybe. There's no impediment for trying to pass the bar. And the other thing too that I like to put on record is if an attorney comes and he works for the government, be it in the Attorney General's office or in any of the branches of the government, the prerogative or the discretion of the supervisor of that attorney remains the same. So there's really no impediment to not approve this proposed rule of admission. I'll move forward, Chairwoman, into the other aspect of the conversation this evening.
You may proceed.
May I proceed? Okay.
Yes, yes,
Thank
sir.
you. I have a little bit of a reservation of constitutional amendments, especially through initiative. I'm not an opponent, but I'm not really a popular proponent. Reason number one, I think it has over the years been obvious that we tend to go through the process of initiating legislative initiative at the last minute of the duration of the representative or the senator. I think I almost call you Your Honor, but it's okay if I wish Chairwoman that what concerns me is the fact that it doesn't take much to push through a legislative initiative. All you need is a majority of the members present. And so I'm looking at it mathematically. If you have a 9-member House of Representatives and you've established a quorum and you have 5 members voting for a yes, right there and then you have already the avenue to pass a legislative initiative combined with senators of 5 that would establish a quorum. And then, of course, if 9 members come, all you need is 5. So, or if 6 members come, all you need is 50, more than half of that. So what I'm saying, Chairwoman, is it seems precarious to me that, we would abruptly think of something and then going through the process, the easiest process, as opposed to, of course, people would argue or they can raise argument that, well, it may not be really that bad because after all, it's going to go back to the people and the people's going to vote for it. But my concern is that's not reality. Reality is that people don't really know what they're voting when it comes to legislative initiative and they just vote. So that's just, I wanted to put that on record that it isn't a concern. And so with respect, for example, of the proposed amendment, Section 10, Article 3, not this one, the one regarding tax reporting. I don't know where I got this information because I was a member of the Second Constitutional Convention. And so and I don't know how this came about, Mr. Props, Congressman Props, how this came about as far as the requirement for every 5 years for the authority to present to the legislature a report of the activities of tax-exempted companies. The concern I have is if I'm the governor and I invited a prospective investor and I push for a tax exemption for that company during my initial term, first year, second year, or third year, and I have to be required to report back to the legislature before I resign or I gave up my job. I just wonder if I'm seeing also the same thing that, or maybe you can see where I'm coming from. I tend to think that there could be a biased reporting. And that's why I think the 5 years is a good reporting period because whoever is going to be the next governor or is going to be the required person to report back, it doesn't have to be that same person. So I don't know why we would want to change that. I think the reporting should be every 5 years. That's my observation. And I quit with that because I think it's an easy observation to make. So there's really no, it provides no benefit at all. In fact, it would be more of a detriment because you don't get the most equitable reporting if like I said, if I'm the governor, I'm the one who's inviting the company that comes into the island to invest. The other concern that I have here, and I'm not a rebel rouser, but I guess you can consider me a rebel rouser at times, but not all the time, is the requirement or this proposal to limit the executive authority to mobilize resources. I worry that what do you call it, an abrupt decision to start the process of changing the rule. I don't know. We come from our island is hit by typhoons. Almost year to year, every year. I worry about an emergency situation coming next year, or the following year, or whatever, and we eliminate this authority of the governor or the executive branch, and emergency situation comes and we restrict in the worst scenario, let's say, as opposed, and you can see, for example, what's happening in Puerto Rico. In the worst scenario, you want to diminish the power of the executive branch. I don't look at it from the standpoint of who is the present governor, but I look at it from the standpoint of the power of the governor to be able to exercise that authority to mobilize resources in time of emergency. I worry. We haven't experienced yet the worst scenario like in the old days when we had Typhoon Karen, when people were about to starve to death in Typhoon Karen. We probably were not born at that time. I was born already, by the way. So I saw that typhoon in Guam, and people suffered like crazy. We were lucky because you too were better off in 2018 than in the year 1998 or earlier parts of 1977 or 75 or 72 for that matter. I believe Typhoon Karen was in 1972. So I think when it comes to emergency, I think we're better off not diminishing, because we still have other eyes to look around and see what is going on around us, and that's just my own opinion. So I thank you for the opportunity to say a little penny worth of words this evening. Thank you, Chairwoman. Thank you.
Thank you, retired Judge Lazama. The floor is still open for public comments.
Good evening. Hello. Good evening, Madam Chairman and members of the committee. My name is Doug Hardig. I'm here as the public defender. I sent a letter, I think it was yesterday, the day before, that basically had my comments in writing. So if everyone has had the opportunity to see that, I have precious little to add. I wanted to comment on the first and fifth items. I'll keep it brief because, like I said, I did put everything in writing, which I hope you've all had a chance to look
Yes,
at, or you
we
will
have.
soon. I would just agree with Ed Menabusen. Oftentimes, we have real trouble recruiting qualified candidates to come out and work in the public defender's office. We need licensed attorneys from the United States. Some people do go from here, come back after graduating from law school, but by and large, we're recruiting from off island, and it's a very expensive process. It can be a very long process, and we've had people who said, I'd stay beyond 4 years, but having to take that quiz was just enough of a push to get me out, and so I'm leaving, or I've left. And then we incur the expense of repatriating those people because that's a requirement in the contracts. We get nothing for that. Then we have to spend the expense of getting someone out here to fill that spot. And the irony of it is, as Mr. Manabusen pointed out, once the person has actually worked in our system and gets an understanding of how the system works and has become more or less an expert, that's when it's time for them to leave, and we bring in another rookie. And so it really is kind of counterproductive. My only negative comments about the proposal is there's some actual specifics which to me aren't clear, where in the 72.3D6 says they have to produce evidence of education qualifications as per 71-2B. That's what that refers to is a transcript and certification that you graduated from an ABA accredited law school. That requirement is in 71.2A. But if you look at 71.2A isn't in this proposal. So it looks like you have to prove by giving transcripts from your law school, but it doesn't actually require you to go to accredited law school. So I just find that as a bit of I don't know if it's a missing link or I'm trying to read too much into it. I'm not sure. Another issue with the way it's written, and again, this might not be the committee's concern, is the way I read it is you can a lawyer could practice for 4 years and then they can apply for an extension for 4 years. What about a lawyer who worked here for 2 years and left and wants to come back? Tagged on to a license with whether it's a day or a decade, can they do that? Or are they barred? Is this one continuous stretch of time? And to me, that's not clear. I don't really know what the intent there is. It could go either way as far as I can read it. But overall, the intent is to extend the time that a qualified attorney can remain in government service. And as far as the bottom line goes, I definitely would support that on behalf of the Public Defender's Office. I'd also like to briefly address the HLI 22-1. I think I spent the more words of my letter in that, even though the attorney admission is more part of my real job function and the main reason I'm here. But I would just point out a couple of things. I don't know that this proposed change gets you where you want to go. I don't know that an elected chief of police is necessarily the best approach. As it stands now, the commissioner can be relieved by the governor or by impeachment. This proposal would make it only by impeachment. So you haven't actually increased oversight. You've cut it by 50%. And I don't really think that gets you where this proposal is trying to go. The way it works for the federal government in the United States, it is in fact the chief executive, the president, who appoints the chief of the law enforcement, which would be the chief, the functional equivalent would be the head of the FBI. And it seems to work pretty well in the United States, and there doesn't seem to be much interference, which apparently this committee's concerned about. The fact also that the elected official would run as a non-party, unaffiliated with a party, but someone who's otherwise qualified, who's, I think, been in law enforcement for 5 years, has resided here for 5 years, is of a certain age. I think it's going to be pretty hard to find that person who isn't already affiliated with a party. Now, they can renounce party affiliation, but everybody knows who they are and what their party is, even though it's not stated on a ballot. So I don't think that really overcomes that issue. Also, where you're appealing to a certain constituency, it lends itself to pandering. You could find that an elected official really doesn't want to be the commissioner. He's looking for Commonwealth-wide exposure for a different office. And so he might pander to people within his constituency, even though it's not really a declared party. This could work to the detriment of certain groups, certain subgroups in the Commonwealth. For example, the residents of Rhoda. We're not going to bother funding Rhoda because they don't have enough votes when I'm going to run for higher office. So forget Rhoda. That's just an example which is conceivable. And so I'm not sure that making this an elected position really gets over the problem that is potentially perceived. And again, it's not the way it's done in the federal government, which I think is probably a better model. A third model, which is very common in urban areas and large police departments, is a board. And if you have a board that has a member appointed for a fixed term of years from the governor, other members who are elected, other members who are appointed that are overlapping but not continuous or contiguous terms, so that different governors would be appointing different board members, you'd have a board which, at least in principle, and I think in practice, would be much more neutral. And I think that the board model is the better model than the elected model. Thanks.
Thank you, Mr. Hartig. The floor is still open for public comments.
Good evening. My name is Sonia Camacho, and I'm the Director of Courts. And I am here on behalf of the Commonwealth Supreme Court for item 4E on today's agenda. And I would like to thank Chairwoman Selena Babauta and the committee for this time for the public to offer its comments for this proposal. We respectfully request the committee and the House of Representatives adopt the proposal as stated from the Chief Justice's letter. And I am present here today with our acting General Counsel, Matt Brown, should the committee have any questions now or in the future. Thank you very much.
Thank you, Director Camacho. The floor is still open. Is there anybody else who wishes to make public comments? I would like to call for a short recess at this time. Here we are now back from recess, and we are back to public comments. So we are still open. The floor is still open for public comments at this time. If there are none, I would like to ask for a motion to go into a committee of the whole in order to recognize some of the representatives and receive their comments as well.
So move.
Thank you, Representative Mangonia. There's a motion on the floor to go into a committee of the whole so we can receive comments from the members as well. Is there any concern or questions on the motion? Ready? All those in favor, please say aye. All those opposed, please say nay. The ayes have it. We are now in committee of the whole. And at this time, I would like to recognize Representative Edwin Probst.
Thank you, Madam Chair, colleagues, and thank you, honorable guests, Attorney General, and retired judge and others for joining us tonight. Thank you for your comments. I just, while we're here, wanted to ask a couple of questions that if you would be able to give some feedback or some answers to a couple of questions I have. So the proposed rule of admission 73-2, Title 9 of the NMI Supreme Court rules, extending the admission from 4 years to 8 years. I guess the first question I have is, have the actual members of the CDMR Bar Association been asked about this for feedback? And has there been a poll of some sort to see where they feel, what the general consensus is of the CDMR Bar Association members? I think that's a voice that needs to be heard from. I have had a few attorneys who have reached out to me who are reluctant to speak during public comments or put their name out because they're afraid of the repercussion of facing potential backlash if they go to court or something. So it's understood. It's understood. But is that something that you would welcome, to see how the attorneys generally feel if they support this proposed rule amendment?
Representative Probst, let me answer that question.
Recognize the Attorney General,
Thank
Madam Wilson.
Thank you very much. I noticed that when Chief Justice submitted the letter and the proposed rule to the committee, that he indicated that the Attorney General consultation with the bar occurred, and I take full responsibility for that. And we did not have a consultation with the bar. For the simple reason was that in my first communication with the Supreme Court, I indicated that one of the things that we could do was actually to the bar about this rule change, and it never happened. I think for the last several, when we submitted our proposal to the Judiciary, sometimes in, I think in October of 2021, we did not have any response whatsoever until most recently, and we caught the surprise. But I know that they were working behind the scenes to try to get it going. And by the time that the proposed rule was proposed by the Supreme Court, we didn't have enough time to go on and talk to anyone. But in any event, I don't believe that there's not a requirement that we consult with the bar in respect to this, but I think it's a good idea, and we didn't do that, and the Attorney General did not do that. Thank you.
Thank you, Mr. Madam Wilson. Recognize Representative Ed Probst.
Someone's mic on? Thank you, Attorney General, and that's just, again, something that it would be a good idea to get a gauge of how the members feel. It's just a suggestion. I am not opposed to this at all, but I just feel that just to get a better clarity for how the members feel, it would be something that could be considered. And there's a few attorneys who reached out to me that asked if that could be done. So I didn't see anything wrong with that. So I'm sorry, Mr. Arctic.
I'm sorry. I can just briefly, as a member of the bar, I can tell you that the bar, the membership was notified of the hearing tonight.
Okay.
And the Bar Association, I'm not an officer in the association, but it's my understanding that the association has decided to not take a position and leave it up to the individual members.
Thank you, Mr. Harding. Yes, we have received the CNMI Bar Association President's letter indicating that the bar does not take a position either way. I would like to recognize Miss Sonia Camacho and her guest.
I like Mr. Hardick, I do not want to speak for the bar, but the bar president did issue notification to its members, notifying them that this has been presented and sent to the legislature, and that they are welcome to comment, and even provided a notification about this hearing tonight.
Yeah, I'm
Thank you. Would you please state your name?
sorry. I'm Matt Brown, and I'm the acting general counsel for the
Thank you.
Judiciary. I'm actually here, on a temporary license for the government myself. So I'm obviously very pro for it. But I was just gonna second what Doug was saying. Yes, that the bar did send out an email on the 21st indicating that the full membership had been apprised of this rule on the August 1st, 2022.
Thank you, Mr. Brown. And for the last round, Representative Ed Probst.
Again, thank you, and that is noted. And yes, they were informed, and I do have a message from one attorney who would like to be here, but is afraid how it may affect this attorney's career. And that's just, I'm not saying that every attorney feels that way, but I don't see, would it be very difficult to put out a poll to see, for those who want to respond to it, to see how they feel about it? Is that something that's possible? That's something that that I would like to see, to see what's the general consensus, because the comments and the feedback that I did get from those few attorneys, not a lot, but just 3 attorneys that reached out to me and talked to me about it, was first of all, 8 years is a long time. And the ones that talked to me, one of the points that they brought up was the fact that, well, they took the bar, and why is this being extended to what point? And is there somebody in particular that this is going to benefit? There were these different points that were raised. So just for complete transparency and everything, it would be nice to see if we could see a poll offered. And if the majority of them say, yeah, we're all for this, then there's no problem. Again, I have no issues with this. I just simply wanted to bring up some concerns that were brought up by a few attorneys that reached out to me who would like to be here tonight, but are, again, not willing to go publicly to speak against this. And I'm not saying that the judges would retaliate. That's not the point. But they are concerned of the possibility of it. And I understand that, that happens in politics. I'm not saying it happens in the courts, but it happens in politics. So that's all, Madam Chair. And thank you for your time.
Thank you, Representative Probst. Is there anybody else? If not, I would like to call for a short recess. Is 6:52 PM. At this point, we will recess tonight's public hearing and reconvene tomorrow afternoon at 2:30 PM in the House chamber where deliberations will take place on the order of business today. Are there any members who wishes to make announcements or comments? I recognize Representative Richard Lizama.
I just want to remind everyone that tomorrow there's the 13 fishermen. It will start at 4 and at 2 o'clock if we start at 2. And how long would that be? Because a lot of us will be attending that event at 4 and some of us will be there at 3:30. Thank you.
Thank you. Is there any other member? Recognize Representative Donald Manglone.
Thank you, Chair. I just want to put on record and make the announcement that if any bar members would like to reach out to any of their representatives to give us a call. I know that the chair had mentioned that any written comments will become official records, but in just trying to help us understand more of the situation, contact any one of your representatives. The decision that the committee will make tomorrow will be presented to the full House. And so whether you want to do it in a committee level or in the House session, reach out to your representatives to help them understand more of how this will impact the law community, especially those who are members of the bar. I know we've heard from the Public Defender's Office and we've heard from the AG, and these entities utilize lawyers that aren't barred in the CNMI. And so hearing from those who are members of the bar, that would certainly help the committee as well as the House of Representatives understand the situation more and to make a more informed decision. Thank you.
Thank you, Representative Manglone. Are there any members, other members who want to make comments or announcements? Thank you. It is now 6:54 PM and this meeting is hereby in recess until tomorrow, Friday, September 23rd at 2:30 PM in the House chamber. Thank you.